apparently they're really busy. All right, well, hope you get out of this, okay?
Griffin, can you turn your
Okay.
Sure. I can't see you, but sure. Okay. State of Wisconsin versus DeQuinn Wiley, 19 CF 2257, 19 CF 2692. Appearances, please.
Jim Griffin, can you state? DeQuinn Wiley appears in person by training me, Rich, good morning, Your Honor.
First, Mr. Wiley, good morning. Welcome to you, sir, and welcome to both attorneys. Counsel both, what is it you wish done in this matter?
Judge, it's my understanding today that the defendant is going to plead guilty to the charges in each information. And the state that sentencing has agreed to recommend prison, leaving a length of the and structure of that sentence up to the court, along with any other terms or and conditions up to the court. And of course, we would ask for restitution if any is requested and it's reasonable.
That's correct, Your Honor.
Can I know in terms of the charges before I interact with Mr. Wiley? In 2692, it's possession of a firearm by a felon, but there are two enhancers. Are the enhancers going to stay or is it going to be amended to delete?
You know, that's a good point, Judge. Thank you. I did file an amended information in that 2692 case on July 31st, eliminating one of the habitual criminality enhancers. That was a law that expired on July 10th. So the first thing we need to do actually is to arraign Mr. Wiley on that amended information, which I filed.
Is that acceptable to you, Mr. Rakestraw?
It is, Your Honor.
Okay, let me pull that up.
It's not in there. Let me pull it in, Judge.
You want me to email it to you, Sharon, so you can print it out?
No, I have it. I just didn't,
I see.
I didn't pull it into the queue.
Mr. Riggs, I sent you an email.
I believe so.
It's not in there, Judge. I'll print it for you.
Okay. Thank you. All right. With respect to the amended information where the charge is possession of a firearm by a felon, habitual criminality repeater, where the maximum penalty would be, normally it's 10 years, but the enhancer makes it 14 years and or a $25,000 fine. First, Attorney Rakestraw, have you and your client received a copy of that document?
We have, Your Honor.
The waive reading.
Waive the reading and enter plead not guilty for the time being.
Plead not guilty is accepted. Certainly probable cause exists based on the entirety in the file. Now, plea is accepted as well, plea of not guilty. Now, that is the charge that the parties indicate there would be an admission to?
That's the first one, yes. You have two cases here, right?
Yeah.
Yeah, affirmative.
Just checking. I didn't listen to the call, I apologize.
All right, and I do have a question, Ms. Rakestraw, on the plea questionnaire and waiver of rights form, you indicate 19 CF 2691, I think it's 2692. May I change the 1 to a 2, or do you want to change it?
2691 is the co-actor.
Oh, sorry. Yep, you can take that to 2. Sorry, that was a mistake on my part.
Okay, no, that council is doing a super job. All right. Mr. Wiley, before I can even ask you what your plea is to these two charges now, I'm required to have an interaction with you to be sure you have certain information about these cases. Now, there are two matters before us. Do you understand that? In file 19 CF 2257, you are charged with one count of operating vehicle without the owner's consent. Have you read the underlying complaint and information in that case? Do you have any question about it? The maximum penalty, if you're convicted, would be a fine of up to $10,000 and or 6 years confinement in prison between initial confinement and extended supervision. Do you understand that? Next, I'd also advise you that in this matter, the state must prove each element of that crime beyond a reasonable doubt. Counsel submitted Wisconsin Jury Instructions Criminal Number 1465, and that indicates that the elements are as follows. First, that you intentionally drove or operated a vehicle without the consent of the owner. Do you understand that element? Next, they must show that you knew that the owner of the vehicle did not consent to your taking and driving or operating that vehicle. Do you understand that element? I'm going to leave that charge and now go to file 19 CF 2692. And that's the amended information. Now, have you read the underlying complaint and this information? The maximum penalty if you're convicted here would be a fine of up to $25,000 and or up to 14 years prison divided between initial confinement and extended supervision. Do you understand that? Now, the burden is on the state to prove each element of this offense beyond a reasonable doubt as well. Here, counsel submitted, let's see, Wisconsin Jury Instructions Criminal Number 1343. And the state must show that you first, that you possessed a firearm. Do you understand that? Next, they must show that, as to the second element, that at that time you had been convicted of a felony before that. Do you understand that? All right. We've gone through the element and the maximum penalty. I now ask you with respect to both charges, the charge of operating vehicle without the owner's consent, and the charge of possession of a firearm by a felon with habitual criminality repeater. What is your plea to both of those cases? Are the facts in each case that are contained in the underlying criminal complaint, are those facts true and correct? Pardon? Has anyone or is anyone forcing you or making you plead guilty? Said differently, are you pleading guilty based on your own free will? When you enter such a plea, you give up a number of very important rights, and I'm going to review some of them with you. You have a right to a jury trial where the jury, in order to reach a decision, must unanimously agree as to either guilt or innocence. You are giving up your right to a jury trial. Do you understand that? Also, in this case, you need to understand that the burden is on the state to prove your guilt if they can, beyond a reasonable doubt. But here you've told me you're guilty, and you've told me the facts in the underlying criminal complaints are true and correct. I want you to understand that that would provide a basis for me to conclude that you are guilty beyond a reasonable doubt. Do you understand that? Knowing that, do you still wish to continue with your plea of guilty to both cases? Now, on your behalf, counsel submitted a plea questionnaire and waiver of rights form as to each matter. Have you reviewed those documents? In the charge of operating a vehicle without the owner's consent, it indicates you're 19 years old. Is that true? It also states you have completed 12 years of schooling and do have a high school diploma. Is that true? Have you fully understood everything that's occurred here in your case today? In the amended information, possession of a firearm by a felon, habitual criminality, counsel has also submitted a plea questionnaire and waiver of rights form. And that document indicates, again, you're 19, you've completed 12 years of schooling and have a high school diploma. Is that correct? Now, you have a right to remain silent and no adverse inference can be drawn from the fact of your silence. Even if you remain silent in the word trial, your attorney would have a right to cross-examine anyone who testifies on behalf of the state, and the attorney could bring forward other witnesses. You're giving up these rights. Do you understand that? The next question goes to the attorneys. On the plea phase and only the plea phase, is there anything more you wish in the record? District Attorney?
No, sir.
Same opportunity, Mr. Rakestraw?
No, Your Honor.
All right, in this matter then, Mr. Wiley, I'm going to make two findings. I first find that the plea you've entered of guilty to both of these charges are pleas that you have entered freely, knowingly, and voluntarily. You've told me that and I accept it. The second finding I make is that your guilt has in fact been established in each case. And that's based not just on your plea of guilty, but the acceptance of all of the data contained in the file, but particularly in the criminal complaints. And based on that, I do find that your guilt has been established beyond a reasonable doubt, and I find that you are guilty in file 19 CF 2257 of operating a vehicle without the owner's consent, and in file 19 CF 2692 on the amended charge of possession of a firearm by a felon habitual criminality been established as well. Now, I'll go to the attorneys. Given the findings made, what do you want done relative to the issue of sentencing?
I would ask for a new date, Judge. We have a victim notification to do on the driving matter, so I'd ask for an adjourned sentencing date.
Okay, so that's required. Could we have a tentative date and time the parties can tell me how that works for you?
We do sooner rather than later if possible.
Okay.
Okay, can we do this via Zoom since the defendant is in custody? Because I can set this for August 24th or 25th at the soonest.
My client would prefer for sentencing to be in person.
Okay.
As the clerk looking for a date, the date of the offense of possession of a firearm by a felon is June 18, 2019. The enhancer indicates that you had been convicted of at least one felony during the 5-year period immediately preceding that date. Is that a correct statement? I know it often I see in the complaint, they list the date. I don't see that date here, but I want to be sure that condition has been met.
August 27th in the afternoon.
Is that what day of the week is that?
Thursday.
Bad. I'm not here that day.
I can do any other day that week, need be.
Okay,
I can do do you do the 27th in the morning, Sharon?
I think I said the afternoon.
Yeah, I'm not here in the afternoon, although,
I mean, I could do the morning. The morning would work better for me than 27.
Are you here in the morning, Griffin?
I am in the morning, yes. Glam's gonna cover it by Zoom in the afternoon, so, he could do it. It's really not that critical, but I guess there might be a victim on this. I don't know who want to speak.
I mean, the morning would be better for me than 27.
Okay, let us do. $11 on the 27th.
Sure.
Okay,
Next court date will be August 27th at 11 a.m. for sentencing.
Mr. Wiley, between now and that date, work closely with your attorney, and you'll be back in court then for sentencing. Good luck to you, sir.
Thank you.
Thank you, Judge.